Morning, everybody. Thank you very much for joining us this morning. We are here to look at protecting your brand. So just firstly for introductions, my name is Jenny. I am the Managing Director here at Dragon Argent. We are a small professional services firm who support all of our clients to solve many problems so that they can thrive. So we've got a team here of lawyers, accountants, lawyers, accountants, tax and business advisors that support all of our clients through their growth journeys. And this morning I'm joined by Margherita, who can introduce yourself.
Thank you. So I'm Margherita Barbagallo. I'm the head of litigation, IP and art law here at Dragon Argent. And today we are going to be talking about how to register and protect your trademarks, which is a specific element of IP. So that is what we'll be doing today.
So in terms of agenda, Margherita is going to cover various things and go into quite a lot of detail about what a trademark is and how to register it, what can go wrong, and then we'll end with some questions and answers at the end. So with no further ado, I shall pass on to you. What is a trademark?
So I think sometimes people kind of conflate trademark and branding. So it's good to kind of distinguish the two. A trademark is a legal tool to protect specific identifiers, and that can be a logo, a slogan, but it's what's identifying your specific business or brand. Whereas the brand is the overall image and it's your relationship that you build with your audience. So it is that kind of emotional connection and market presence that you're going to have. And that can incorporate many things. It can be a trademark, but it can also be, your image, just on a broader scale. So trademarks form part of the brand, but the brand is more wider than the trademark itself. So the benefit of the trademark is that it's actually a legal protection, and it can give you exclusivity to your name, your logo. So it gives you basically an enforceable right for you to exclusively use it, and then you can use that to protect yourself and to prevent competitors and third parties from using it. So that is the key distinction between the two.
So what can be trademarked?
Yes. So we've got here a list of the various trademarks, the things that can be trademarked. I think sometimes people just think that it's the name and the logo, but it actually is quite broader than that. You can trademark a slogan, you can trademark a domain name, a jingle, a color theme. It just needs to, the test is it needs to be distinct, and we'll get into that a little bit further, but it is quite broad in theory. For an international trademark, which I'll explain a bit, we're in a very international world right now. So if you're doing, and I see this a lot with our tech companies, they may only register in the UK, but your online presence is in different countries. If you do file for an international registration, then you have the opportunity of getting global protection, even if you're mainly operating within the UK. And lastly, it gives you long-term security. Trademarks are registered. Once they're registered, they're granted for 10-year periods. So you renew every 10 years, which is a nice chunk of time that you don't have to, you don't have to worry about it. You have that protection for a decade, essentially.
On the international protection, then, does that cover? So you'd apply. Do you go into that how this actually works? How to apply in the UK?
Yeah.
Okay.
We'll go to the UK, and I'll explain how that where you go from there on if you want to do a global one.
Okay.
So this is the example of what happens in the UK, what the actual application process is. So you do start off with, this first bit is something that I always recommend to clients, is basically conducting clearance searches on the mark that you want to register. I can't stress that enough, just because you might think that it's a unique name. You'd be surprised how many times I've seen it where something similar is actually out there. So by doing your searches, you're doing your due diligence. You can run your searches on the UK IPO search engine. When we run searches, we do something very much more comprehensive because sometimes the UK search engine is not the most thorough, yeah. So I always recommend complementing that with other type of searches, which is what we do. We go on databases, things like that, and you're essentially looking to what's the risk there. There might be someone that has a similar name, not identical. Is it similar enough in the goods and services that you're providing? So we often give our clients a risk assessment on that before proceeding to apply, basically telling them, there's these marks out there, might be a little similar. This is what the risk is, high, low. And then we make a decision together whether or not to actually apply. So once you have done that bit, and again, doing it beforehand is better than after, because once you've filed and paid those costs to the UK Intellectual Property Office, if it's rejected, if it gets opposed, those fees are lost. You might have to then rebrand as well, so best to do it before you actually apply. So you start off with your searches, then you prepare. What we'll do for clients is we prepare what's called a class specification list. So often people will attempt to file the trademark application themselves, and there's an actual classification list. There's 45 classes out there that you choose from. So it could be class 45 under medical services. They're set out what each class is. That is actually the most important part of your application, because you want to make sure that you're putting in all the services or goods that are relevant to ensure that you're only going to be protected in the classes that you list. So you want to make sure that you're picking all the classes that actually apply to you now, but also potentially in the future, because when you do file an application, it's done. You can't amend it later on once it's registered. It's set in time. So you can't add on classes. So if you are growing your business down the line, you may not have thought that I wanted to do some training in this area, and you didn't file for that class. You'd have to file a new one. So we do go through this with our clients as well. What are you looking to do now? What are you looking to do in the future? What are the classes that are relevant for you? And then actually describing what those terms are in each class. I see a lot of clients that just put, one or two terms, in a class, and that's actually going to restrict the protection that you get for it. So preparing, I said file trademark here, but it's actually prepare and file for the trademark application is the step that you'll take next. Once that's actually then filed with the office, it'll be examined by the examiner at the UK IPO. The way that it's examined, it's case by case, and sometimes you could get conflicting decisions because it is internally done. So that's why we do recommend getting some legal advice when you prepare, because one examiner might accept it and then another one might not. So that's why here we have in the next stage that you might get an objection from the examiner. And that just means they might not agree with a term that you've put in or a class that you've used, or they might take an issue with whether or not your mark is registrable. Like I said, if they think that it's descriptive, it's basically their time to review it and push back. So the examiner might object to it. If they give you an opportunity to respond, so you can respond. Oftentimes you can overcome it if it's something like the class term is the wrong term, you just change it, that's fine. So if that does happen, then you respond, it gets accepted to publication, and that means it basically gets put on the public register for 2 months. And that gives an opportunity for any third parties to oppose if they think that their mark is similar or identical to yours. And the UK IPO will send out notices to existing trademark holders if they think that the mark that's being applied for is similar to theirs. So they'll notify them, but it's a public register as well. So some people have a kind of a search function or something in their system to basically notify them if someone's applied for something similar. So in that 2 months, you might get a notice from a third party saying they're going to object to the application application because they have a similar mark, and that's where the red button goes down, third-party opposition. At that point, you can either negotiate, you might have to negotiate with them to try to come to a resolution, but if you don't and you can't, then there's opposition proceedings, and that's an actual, legal process that's run by the UK IPO. It's not a court. It's more a UK system to resolving the issue, but it's proceeded court-like. So you do have a hearing, you have to file evidence. So it is a costly process, and there's a cap on the cost that you could recover in terms of if you've had legal representation and the cost that you've incurred to do that. So, they're very, very backlogged right now, a year backlogged. So it just means that's why I stress the clearance search so much beforehand, because it minimizes the risk of a third party opposition, because if that does happen, that is going to give you some uncertainty, and there could be costs associated with and all that. So you just want to avoid having to deal with an opposition. But if that doesn't happen, or if you succeed in it, then the ideal situation is you wait the 2 months, there's no opposition, and then it's registered. So technically, you can get it registered within 2 months, which is why I was saying it's a relatively quick process, with the caveat that it's not opposed by a third party. But that's it in a nutshell.
Okay, so that's interesting about the backlog as well, though.
Yeah.
Is it looking? Are there any signs that the backlog is? They're working. They're giving more. Putting more capacity to reduce it. So you think it's here to stay?
Yeah.
Okay.
Yes. So once it's actually filed, you've got your trademark registration. UKIPA will send you a certificate of registration. You're all good to go. There are things to consider just in terms of maintaining it for yourself. So we just set out here some post-registration recommendations. So it is good to diarize your renewal dates. It's 10 years from the date that you file it, not the date that it's granted. But when you get your certificate of registration, your UKIPA will tell you, what the filing date is, and they will notify you. I believe it's a month before it actually expires. But it's always good practice to keep record of it for yourself, because human error, you never know if you don't get the notification. You want to make sure that you do timely renewals. So do keep track of that. Be diligent about the use of your mark. So that is a technicality. If you get a registered mark, yeah, you do have it for the 10 years, but you should be using it. So if this is kind of to avoid people registering marks that they're not using, and then kind of getting a hold on in the market and preventing other people that would like to use it. So if you're not using it, it is possible after 5 years for a third party to essentially submit a cancellation application against you, and they'll try to say that you're not using it, so you shouldn't be entitled to it, and UKIPA can revoke a trademark if it determines that you're not actually using it. And something I see here sometimes is you might have registered it in your name, and then you incorporate a company, you've not transferred it over, so technically you as a person aren't using it, your company is, but yeah, you're not, so they might say you're not using it. So you do want to be careful there, and that's where I've got report any changes as well. So if you're changing, from yourself to a company, make sure that that's recorded. Do get some advice on that if you need, in terms of making sure that everything is up to date on the UKIPA registrar. Sometimes you might assign it as well if someone buys your company or something like that. So you need to update those details to avoid any issues down the line.
And so presumably your company name changes even little bits, that would count as something that you need to do to update.
Yeah. Okay. So common pitfalls, kind of touched upon this as we went along, but yeah, inadequate searches is the big one. So as I was saying, before you file the trademark application, you want to conduct really comprehensive searches, and I do recommend getting someone with a legal professional to help you with this, because there's a lot of different databases out there. You have the UKIPO one, but if you are looking to expand your business, or if you're going to operate globally in different countries, you're going to want to search the registrars in those countries as well, and they might be a little bit tricky. So it is good to get some second opinions on that. Google search is great, but it's never going to be comprehensive, so you don't want to just rely on that beforehand. So doing a comprehensive search is always something that I really recommend, just to make sure that you might find something that's a similar name, but doing something that's completely different to you. And the benefit of having a risk assessment reviewed by a professional, they'll tell you whether or not those similarities are likely or not to be an issue. Because when you're looking at an opposition proceeding, the test is there a substantial similarity, and will the public be confused by the two marks? It is a legal test. So when you're doing your searches, it's not just searching it, but actually doing a review of whether or not what the risk of that is in terms of an actual potential opposition. So doing the searches, definitely recommend that from the start. And that's where I see a lot of issues rise from the beginning. And then the next step is having those goods and services identified properly in your trademark application. And that is another issue that I do see with clients that have filed it themselves, and having very minimalist terms in there, 3 or 4 words. It really does restrict what your protection is. So even if you're a med tech company and you file in a class that it's for medical services and that's it, it's limiting what protection you actually have. And I don't think people realize that so much. So when we draft these class lists, they're quite meaty, and you don't want to be over broad, because you have to balance that with the fact that you have to be using it for that purpose. So it is a bit of a balancing act, because you want to protect your business for the future development of it, because you want to be comprehensive, but you don't want to overreach, because then you run the risk of more positions, the more classes that you have. So it is a fine balancing act that we advise getting some advice on that. And then another big issue I see is neglecting the international protection. So a lot of times I'll have a client who's UK based, and so they'll only file in the UK. But we are very much a global world, and you don't realize the way that it impacts you globally. So I have had some example where only filed in the UK. They found a Dutch company that had a similar name, and they knew that people were going to that website by accident, because then they were being diverted, but they were competing services, and some of their potential clients were actually being poached. So you might, if you're giving a service that is an online service, it could be very easy for other third parties in other countries to be a competitor. So you don't want to avoid the risk of neglecting international protection. And here I've referred to, Jenny, to your question, what that is. How do you do that? Basically, once you file your UK application, you get 6 months to file an international application with the same filing date. An international application is done through the World Intellectual Property Office, and basically there's all these participating countries that partake in it, and it gives you the opportunity to file one international application, but then you just select the countries that you want to file in. So it's more streamlined. It's one application as opposed to going to every IPO office in every country, and it helps minimize costs by doing that, because it's all streamlined through the World Intellectual Property Office. If you want to keep that same date as your UK one, there is that 6-month period you have to be aware of, otherwise you lose that priority date. Doesn't mean you can't file it later, you can, you just don't have the same date, and you have to be mindful of 2 renewal dates that you're going to have. But I always recommend that international application, because it will give you an opportunity to protect globally in a more, not necessarily faster, because then you are still subject to those offices and how long it takes for them to process it, but a more cost-effective way, for sure.
So does it cover, so you said that some members of some countries are part of it, but I mean, it's still obviously a lot of, like the bulk of countries that you would be looking to transact with are.
Yeah, most of the big players are participating countries. You've got, you know, US, EU, UAE, that we see that a lot. People wanting to trade in China and things like that. Those are all there. There are, you know, some caveats. For example, Saudi Arabia is really a developing country that people are looking to protect more and more. They've technically joined the Madrid Protocol a few years ago, but they haven't enforced it yet, so they're actually not part of it. So you just have to look at who are the participating countries to see if you can select it, but most of them are available. And finally, protecting yourself against infringement. So as I mentioned, you have a registered trademark that gives you exclusive rights to it. So you do want to keep track of what's happening to make sure that you're not being infringed by a third party. So monitoring for infringement, just, you know, occasionally doing a search to see, you know, what has there been a company that's started that's new. You can do that through Google searches. You could do it through Companies House to see if there's a similar company that's been incorporated. But, you know, just regular checks is always good practice to do. And then enforce your rights. So if you do see that someone is using your trademarked name or logo or mark, generally what we do is, you know, we start off with a legal letter that could be a cease and desist or a letter before action that basically sets out what your claim is in terms of trademark infringement and the steps that need to be taken by the other side to basically stop. So you do have the ability to go, you know, down the course through trademark infringement, but usually once you have the actual trademarkable mark, the letter tends to be a good starting point for resolution. And then maintain the trademark registration. As I said, do the renewals if you are using it past 10 years. Make sure that you're using them, like I said. So you know, if you can let it lapse, but just if it is something that you want to, you know, keep on hand, it has to be in a company or a business, then you have to be using it. Expand as needed. Consider the global protections if that's something that's of use to you and your business. Document and evidence use. This I say because you might not have, even if you, sometimes if you haven't actually registered yet, and then you see that someone is registering, you can argue that you have prior use, or they might have registered as well somehow, or in another jurisdiction. You could argue prior use. That is a way to kind of overcome that issue with the IPO office. So if you could show that you've been using that and it's been recognized by the public and it's been, out there for at least 5 years, then that can give you basically a foot up. So you just want to make sure that you do document when you start using your branding, and that could be websites, notes, anything that can that's contemporaneous and that shows that you've been using it at that period of time. And then do consult legal professionals because it is it's a relatively, you can do it on your own, but there are these little issues that creep up. So it's good to get some advice in terms of the sense check what your mark is, whether you think that there'll be any issues, or if you do have somebody like a third party that you think is using a similar mark, to get some advice on that as well, because you want to make sure that you just continue to address it so you can protect your brand going forward.
Okay, thank you very much.
Thank you.
So we've covered lots of different parts of this at the moment. So we've got a couple of questions here. So the first one, Annette, is at what point should you register for international market? Should it be when you launch your brand, or should it be later?
So If you want to keep that same priority date, you do need to do it within 6 months of having filed the UK one. Keeping the priority date, trademarks are a first to file system. So, if someone beats you to it, and they register it, then they beat you to it. So as a safety measure, I would say that if you know you're going to be looking to certain international countries, then do file the international application, and keep that priority date. But if you're really not sure, then you can wait, and you might lose a few months of that priority date, but maybe that's, on balance, that's fine for you, because there is a bit of it does cost more than the UK application. In the UK, it's £370 plus £50 per class. So you'd be looking at a few £100s. Whereas with the international application, depending how many countries you choose, it could get a bit expensive. So if you're not looking at that market seriously yet, you can wait. But it's a bit of a balance in terms of deciding what the risk is there.
How expensive are we talking? Like I mean, it must be in the thousands, presumably.
Yeah, but it will depend on the country that you choose. So some countries are, US tends to, for example, be more expensive. If you select 3 countries, and also depends how many classes you select. So let's say you had 4 classes and you wanted to do 4 countries, you could be looking at 10,000 for one application. But you can always, there's a calculator, so you can always assess what those costs are before actually filing.
Okay, so that's just on the website, the calculator.
Yeah, if you go on the World Intellectual Property Office website, you can see all the parties that are part of this Madrid protocol for international application. You can then select the countries, and it'll give you an estimate.
Okay, perfect. So next question is from Deepak. So that's your questions about patents. Now that's not something that we look at. Why do we not?
No, so patents are a very specialized niche area, and there are patent attorneys that specialize in only patents. The process for filing a patent is much longer than a trademark application. It will take a few years, and there's a lot of technical analysis that needs to go into it, because it has to be an invention, and then there's a process in determining whether or not that is the invention, and so just to get it filed, cost-wise it is much more expensive as well. So UK, as I said, maybe a few hundred for the trademark, you're looking at thousands for a patent in the UK, and that taking a few years, and you have to meet the test for an invention. So it's a very niche area.
So if somebody wants to go, if that is the area that they want to go down, where should they? Where are there patent specialists, lawyers, who would be the right place to start?
Yeah, just look. You'd want to look for a firm that has patent attorneys, licensed patent attorneys, and then they'll be able to help you with that. They'll also be able to advise you on whether or not you have something that can be patented.
Okay, perfect. So last question so far is from Jess. Thank you, Jess. So does the US have a similar process, or is it completely different?
They do have a similar process. So theirs is the US Patent and Trademark Office, and if, for example, you did an international application, you could do it. You could select the US. They will have, in my experience, they tend to have a lot of objections. So it is a longer process when you're filing in the US than in the UK. From what I've seen, you're looking at more towards a year to get it filed. But that's fine. Like if let's say you start in the UK, then that can just run in parallel. But they'll do the same process. They'll examine it, and that's where I see actually a lot of the backlog is that their examination process, they come back a few times. But then it can get filed. There's a similar opposition period of I think 2 months as well, to see if there's any third parties that oppose, and then you'd have the registration in a similar way. But in the US, they are a bit more vigilant about the use of it. So you actually have to file proof of use when you renew it, whereas you don't have to do that here in the UK. You can just renew it. So they're a little bit more tricky there.
And so they present, but they do have a centralised office that's not by state or anything like that.
Yeah, it's in the US. Yeah.
Okay. Great. Well, that's all the questions that we got. Thank you very much, everybody, for joining us this morning. We hope that you've taken away some useful tips. We'll be sharing the presentation with you. So please feel free. We'll be sharing Margherita's contact numbers afterwards as well. So please feel free to get in touch. Oh, hang on. There's one more. It's about an e-certificate. So when can we receive the e-certificate? So I think that's...
Oh, well, so yeah, so once you, I assume you mean the certificate of registration, if that's what you mean, but that is basically once the 2-month period is passed, if there's been no opposition, then they'll register it and they'll issue a certificate. So that's usually done you usually get it within a week of the passing deadline of the opposition period.
Okay, perfect. Sorry, that last one snuck in there. Okay, thank you, everybody. And yeah, please get in touch if you've got any questions, or if Margherita can help you with anything that you're looking at. Have a happy rest of Tuesday. Thanks all. Bye bye.